Mercy and blessings of God be upon you, dear friends. Today, we are going to talk about a very important topic, especially those who work in the United Arab Emirates, because we are going to talk about what are the cases of termination of employment in the United Arab Emirates. Wait for us to tell you what are these cases.
Peace be upon you. Don't forget to like the video and subscribe to the channel, encouraging us to continue to publish more. God willing, please activate the bell to receive all new.
My friends, the employment contract in the United Arab Emirates ends if there is any case of case 9 that we are going to talk about right now. If there is any case of case 9 that we are going to talk about right now, the contract between the employer and the employer ends. The first case is if there is an agreement between the employer and the employer to terminate the contract. If the employer and the employer have reached an agreement and the contract has been terminated, and the agreement has been terminated, the contract is terminated. This is the first case. The second case is if, as we have said here, the contracts must be in accordance with the new termination law. Previously, it was permissible to program contracts without termination. However, after the amendments that were issued about 2 or more years ago, all contracts must be terminated. In this case, the employment contract terminates. This is the second case. The third case is based on the wish of one of the parties. It is the right of any of the parties to terminate the contract, but there must be a legitimate basis. The other party must choose to terminate the contract. This is called the termination period. The termination period must be terminated. Of course, the termination period is agreed upon in the employment contract. Its exact duration is specified so that no one can violate this period. The third case is based on the will of one of the parties of the contract of the worker, and that is on condition that the person who wants to terminate the contract must abide by the period of warning which is agreed upon in the contract of the worker, because the period of warning differs from the other contract and the law specifies the minimum and the maximum limits, and we will specify this in the next lecture. The fourth case is the death of the worker, but on condition that the contract of the worker is related to him personally, that is, if the relationship between the worker and the owner of the work is related to this person, then the contract of the worker ends with the death of the owner of the work also. The contract of the worker ends, which is the case after the fifth. The contract of the worker ends with the death of the worker or his absence from the work completely permanently, that is, there must be a complete absence, and permanently if his absence is partial, the contract of the worker does not end well. The next case is the sixth case. If the worker is sentenced to a final sentence with a penalty restricted to freedom for a period of less than 3 months, that is, if the worker commits any offense, crime, and he was sentenced to a penalty restricted to freedom, the penalty of imprisonment for a period of less than 3 months, in this case, the contract of the worker ends, on condition that this penalty is final and permanent. Well, the next case, the seventh case, is the closure of the facility, a final closure, that is, if the facility is closed, a final closure. In this case, all contracts of the worker end. The eighth case, the bankruptcy of the owner of the work or the month of his imprisonment. The next case, if the worker did not comply with the conditions of renewing the contract of the worker for any reason other than the will of the owner of the work, that is, if the reason for not renewing the contract of the worker is that the contract of the worker does not end, but if the worker did not comply with the conditions of renewing the contract of the contract of the worker ends, and the worker does not have any income. In this case, the worker has the right to end the contract of the worker without returning to the worker. These are the reasons for the termination of the contract, which is mentioned in the Emirati labor law. But the question that arises now is, what is the period of warning which the law has decided and has stated frankly in the labor law? The Emirati labor law has decided that it is permissible for the employer or for both parties of the labor, let's say for both parties to terminate the contract for any legal reason, provided that the other party is writing the warning. Also, the contract must be subject to the period of warning agreed upon. provided that this period of warning is not less than 30 days or more than 90 days. It means that in the contract it is possible that the period of warning is a month or 30 days, or it can be 2 months or 3 months, but it can't be less than 30 days, and it can't be more than 90 days, which are 3 months. During this period of warning, the contract continues during the period of warning and ends at the end of the period of warning, and the employer deserves the full reward during the period of warning. Also, the party that didn't comply with the period of warning must lead the other party to what is called the replacement of the warning. It means that if I came today, whether I am the employer or the employer, and I terminated the contract between me and the other party without being threatened by the period of warning, then I, in this case, must pay or compensate the other party. What is the value of the period of warning mentioned in the contract? Even if the other party didn't get harmed by the period of warning, it can't be said that I am the employer and today I terminated the contract with the employer and the employer didn't get harmed because he worked somewhere else. No, the law, even if it didn't harm the other party, he has the right to get the value of the replacement of the warning. Okay, how do we calculate the replacement of the warning? The replacement of the warning is calculated according to the law of the UAE, according to the last wage that the employer paid. Okay, if the employer, or if he terminated the contract with the employer, does the employer have the right to be absent from work for a while to look for another job or not? Honestly, the law was clear in this point and said that if the employer terminated the contract, the employer has the right to be absent during the period of warning or the period of warning, 1 day of work without a wage during the week to look for another job. And the employer doesn't have the right to prevent the employer from getting this leave, because this leave is determined according to the law of work. This makes us wonder if there are cases where the employer can terminate the contract, and the employer has the right to terminate the contract without warning. This is what I will answer in a moment. Stay with us. We are back again to find out what are the cases where the employer has the right to terminate the work without a warning. The first case is the proof of the employer's dismissal of another person, or the submission of false certificates or documents to the employer. If the employer discovers that the employer has submitted false certificates or documents to him or her, in this case, the employer has the right to terminate the work without a warning, or to be given the period of warning in the contract of work in which the law has determined. The second case is if the employer has committed a mistake, a serious financial loss to the employer, or the employer has deliberately harmed the property of the employer. If the employer has committed a serious mistake, and the employer has committed a serious mistake, related to this mistake is a financial loss, or the employer has deliberately harmed the property of the employer, in this case, the employer has the right to terminate the work without a warning. The third case is if the employer has violated the instructions of the established internal system related to the safety of workers. In this case, the employer has the right to violate the instructions of the established internal system in a public place so that all the workers can look at it and comply with it. The next case is if the employer has violated his duties, especially according to the contract of work. The contract of work stipulates certain obligations on the employer, and he must comply with them. If the employer has not complied with these duties, the employer has the right to terminate the work without a warning. The next case is if the employer has disclosed a secret, and the result of disclosing this secret is that he has committed a loss to the employer, or he has lost a chance to the employer, or he has turned a personal benefit to the employer himself. In this case, the employer has the right to terminate the work without a warning. The most important case, which is repeated with us, and we see it a lot in the reality of work, which is the presence of the employer during working hours in a state of drunkenness, or being affected by a drug or a mental effect. If the employer is present during working hours, being affected by a drug or a mental effect, or being affected by drunkenness, in this case, the employer has the right to terminate the work. The next case is if the employer has assaulted the employer, or the manager, or one of his colleagues, by saying or doing something contrary to the law. The next case is if the employer has disappeared from the work without a legal reason. Let's be clear. If the employer has disappeared from the work without a legal reason, or the employer has been exempted for more than 20 days, or more than 7 consecutive days. If the employer has disappeared for more than 20 days, or more than 7 consecutive days, the employer has the right to terminate the work without delaying the termination of the work. The last case, after the last reason, or the employer has the right to terminate the work without delaying the termination of the work, is if the employer has assaulted the employer without the permission of the employer. This makes us wonder if there are cases in which a worker is allowed to leave work without a warning, like there are cases in which the law has determined that the worker can leave work without a warning. This is what we will discuss in the next video. Stay with us. We are back again to know what are the cases in which the worker has the right to leave the work without a warning without preserving all his rights as stipulated in the law, such as the receipt of leave or the compensation of the end of the service or his salary or anything else stipulated. According to the labor law, the first case with us is the dismissal of the worker by obligations and the direction of the worker in the contract. We have said before that if the worker dismisses the obligations stipulated in the contract, then the worker has the right to terminate the contract without a warning. The law also gives the worker the right to terminate the contract if the worker dismisses the obligations stipulated in the contract. In this case, the worker has the right to terminate the contract and leave the work without a warning. The next case is if the worker commits a violation of the contract or if the worker violates 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 the contract. In this case, the worker has the right to terminate the contract without a warning. If there is a serious threat to the safety of the worker in the workplace, the worker has the right to terminate the contract or leave the workplace immediately if he finds that there is a serious threat. If the worker commits a violation of the contract, the worker has the right to terminate the contract and leave the workplace without a warning. With this, we have answered the questions that are in many minds of those who work in the UAE. Through this video, we have learned what are the cases in which the worker can terminate the contract without a warning. What are the cases in which the worker can leave the workplace without a warning? What are the cases in which the worker can leave the workplace without a warning? What are the cases in which the worker can terminate the contract without a warning? With this, we have reached the end of the video. May Allah's peace, mercy, and blessings be upon you.